We hope you enjoy this episode of the Modern Divorce Podcast. But first, an important message for our listeners.
Embarking on a new chapter? Zach Nutzman of the Darwin Wall team at Realty One Group is your go-to real estate expert in Arizona, specializing in guiding couples and families through their real estate needs while experiencing a divorce. Modern Law's trusted partner, Zach, brings expertise, confidence, and compassion to your real estate journey. Let him help you navigate this challenging time. Zach Nutzman, your modern solution in real estate. Visit ZachSellsAZ.com to get started. Hello and welcome to another episode of the Modern Divorce Podcast. Today you are in for a treat as I am joined by my friend Rich Harris, who is an expert family law attorney who has a lot of experience representing professional athletes. So we're going to dive into the details of what it means to represent professional athletes, things that professional athletes need to know, unique challenges that face them. Rich is the owner of Harris Law Firm, or is it Harris Family Law?
It's the Harris Law Firm. You had it right, Billy.
Harris Law Firm in Colorado. I send all of my family law clients looking for help in Colorado to you, Rich. Welcome to the show.
Thank you, Billy. And I feel likewise about you and your great practice in the Phoenix area.
Thank you. Thank you. So before we dive into professional athletes, tell me a little bit about your firm.
Sure. We're a family law practice in Denver, Colorado. At least that's our headquarters. We're probably the largest family law practice in our region, the Rocky Mountain region. We've been in business for 30 years, I'm proud to say, and knock on wood or Micah, whatever this might be. We recently added an estate planning offering for our clients as well. We love what we do, like you do. We care a lot about people. We care a lot about solutions and being discreet. And I think that fits well with what we're going to talk about today.
Absolutely. So confidentiality has got to be one of the biggest concerns for professional athletes.
Yeah, it definitely is. We have a separate entry process for our higher end clients, not just athletes, but other folks in the public eye. These are folks who, look, divorce or family law matters in general can be embarrassing. They can be sensitive, as you well know. But for people in the public eye, the last thing they need to do is have to deal with one of these situations and then have their stuff, aired out in the public sphere. So doing what we can to protect them is really one of our top priorities.
Well, tell me about that. What is the separate entry process?
Yeah, you bet. So most often, but not always, when we get one of these matters, it's a referral. So typically somebody's going to call me in another state or another country and say, look, we have this individual. Are you interested? We find out a little bit about the situation. Obviously, we clear a conflicts of interest check like with any client. And then rather than those folks going through our regular intake department, and don't get me wrong, our intake professionals are phenomenal. They're really good and they love what they do. But for somebody of this nature, they typically get right in touch with me. We schedule a meeting. Unlike a lot of other people, it could be, hey, Rich, can you talk to this person now or 10 minutes from now? And unless I'm in court or there's something really pressing, we really need to try and say yes, because these folks tend to have crazy schedules and limited availability. We get them scheduled with me personally. We don't identify them by their actual name on any of our firm-wide communications. We'll use a pseudonym or an initial set for them. Typically, the only folks who know the identity would be me, an associate I work with, and a paralegal, and that's it. Everybody else from the billing department on through, others in the firm, the identities of these folks are completely confidential. My partners don't even know.
Wow.
who they are. And we take that really, really seriously.
So does that mean the matter that's set up and the name of their file and everything throughout the firm is going to be in the pseudonym?
Exactly. Everything. In fact, we train the couple folks I work with on these cases to not even refer to the client by their full name, and even emails between us working on the case itself in case we misroute them or make a mistake. But yes, the billing doesn't include their name. All the files do not include the name. Even when we file stuff with the courts, almost always we're using initials or a pseudonym in the pleadings. That's at least if we file the case. Obviously, if we're defending and somebody else has already filed, that's a different situation. We deal with that differently.
Okay, let's talk about that for a minute. How do you use pseudonyms in pleadings?
Yeah, so in Colorado, our preference is to file within the juvenile court system. And with the juvenile courts, judges and judicial clerks are very used to having initials instead of full names to protect privacy, especially around children. So we will use the initials. The courts accept that, and we will then take extra precautions with the courts, including making a motion to seal the records.
I want to talk about that too. So I have interviewed LA attorneys who represent a lot of celebrities, and in LA, they don't seal cases.
Really?
Yeah, and in Arizona, we moved to seal cases. Like if I have a high profile case, I'm going to look to seal that immediately. And he was telling me they don't do that in California. So you do that in Colorado.
We always do that. And, it's one of the first actions we're going to take on a case if the name is already out there. You're going to pick up the phone, call opposing counsel, hopefully get an agreement to do that. And then in addition to that, we have a confidentiality agreement that it's usually the client and or his or her agent that's pushing it. Everybody signs off on that extra protection. The lawyers, the paralegal, any experts we hire, they don't see any of the information without signing that confidentiality agreement or NDA.
I think that's so important. So we as lawyers and everybody in our firm have obligations of confidentiality anyway, but taking that extra step, reminding everyone involved of their duties is just a great idea because humans talk.
They do. And let's face it, these are folks in the public eye. The people are interested in them. I'm a sports geek myself. It's part of the reason I love this practice. I think I really understand the industries involved and the dynamics, but it's interesting to me too. And I really, really have to discipline myself not to tell my kids, not to talk about it with friends, because, this is important. It's our duty.
Right. So interesting that you can file in the juvenile court. So we are not allowed to file in the juvenile court divorce cases, but you're allowed to take divorce cases to juvenile court?
Good question, Billy. Actually, if it's a traditional divorce, we are going to have to file in the regular adult court. What we're seeing very often in these cases is it starts as a paternity matter. So somebody's trying to either prove or disprove paternity, and those end up in the juvenile system. If it's a straight divorce or legal separation, you're absolutely right. That's the adult court. We're going to need to move to seal as quickly as possible.
Okay. But your regular paternity actions happen in juvenile court?
They do. They do. That's where we routinely, we actually have the option of putting them in the juvenile court or the adult court. For the confidentiality reasons, we most often choose the juvenile courts.
Awesome. Great. Let's talk about the financial implications and complexities involved with assets, contracts, endorsements, fluctuating income. How do those impact divorces or paternity and child support actions involving athletes?
Right. So It's a really interesting situation because the actual disputes and the things people fight over are the same, whether you're super high level income or you're regular consumer. The things we fight about tend to be the same. It's just that the numbers are much bigger and the assets are much more complex. What we find most often with athletes in particular, compared to other high end earners, is they tend to not have the best day to day understanding of all their finances and their investments. They tend to have agents and financial folks and other handlers, if you will. And these are professionals that we work with probably as often, if not more often, than directly with our clients. The athletes trust these folks. These folks, in my experience, really care about the folks they're working with. So when it comes to getting the data, getting the documents, we're going through these third-party financial advisors, first of all. And then we're using those folks to help us evaluate everything moving forward. But then in terms of presenting the case, it's similar to most other cases. Child support and maintenance or alimony are always challenging because I think you have guidelines in the state of Arizona as well as we do. Our guidelines don't apply to athletes by and large because their incomes are too high. So the amount of child support that's ordered is always discretionary with the courts. So it's often the case that we end up fighting over those amounts, and we're trying to protect our clients from an overreaching significant other or soon to be ex.
Well, right, because athletes can have hugely fluctuating incomes, right?
Absolutely. It's not only the amount, but you're absolutely right. It fluctuates a lot. And, for example, a professional football player may only have 3 or 4 years of decent earnings.
Right.
And they start with, well, historically, they start with zero. Now, in these days in college, you have the NIL stuff. So college athletes are now making some money. But they're making very little. Then they go to the pro world. They get giant contracts for a limited period of time. A lot of times, all the money is not guaranteed. There are contingencies and bonuses. You can get injured, and depending on the sport, you could lose all of your income. So we lawyers really have to pay attention to that stuff. And frankly, help educate judges who, let's face it, judges are dealing day to day with consumer folks who are making much less money, and they see an athlete in front of them and they think, wow, this is unlimited income. That's not the case. It's definitely not unlimited. And even though it's a larger amount, again, it's only for a few years in most cases.
So what do you typically do? Do you take that, take the average number of years, look at what that income might look like over a lifetime and come up with a different number to use for the calculators?
Well, it's a good question. So for child support in Colorado, we're required to look at current income, what's happening right now. But we're going to, if we can, put in placeholders for reviewing the orders at periods of time in the future where the income's likely to change. We're also going to follow up with that athlete at those junctures when we know there's a period of free agency, there's the end of a contract period coming up for other reasons. Maintenance, you're exactly right. For maintenance or alimony, we're more often looking at averaging, and we're looking at future streams of income. And we need to be very careful that an athlete is not agreeing to too many years at a set amount beyond their ability.
Alimony is hard. Is it modifiable in Colorado?
It is in most cases, But if you agree to a specific amount, it's called contractual maintenance or alimony, then it's not. And sometimes there's advantages to that, but we need to be careful.
Right. It's definitely risky. Are you a community property state?
We are not.
Okay.
We are not. We're an equitable division state. And, that means the judges have even more discretion than in a community property state. And judges have a lot of leeway on where to go on these cases.
So if somebody is getting money from endorsements, would that money be divisible generally?
Yes, it would be. I mean, it's part of the athlete's brand. It's part of their income, which tends to be fairly regular. You have endorsements that are typically contract-based. And for the top athletes, that money is a pretty steady stream, with one big exception. We see a lot of these cases where there's domestic violence allegations or other allegations that are certainly negative for lots of reasons. Domestic violence, for any family law attorney, I'm sure you would agree, is something we care a lot about and we take seriously. But for people in the public eye, they're really susceptible to false allegations. And I bring this up here because we see cases where you have a parent who's making a false allegation involving the police, and all the while he or she is thinking, well, this will look great for the parenting issues, and that might be true. But you're kind of, killing the goose that lays the golden egg, because that stuff gets out there, and all of a sudden teams are thinking twice about renewing contracts. Brands are running for the hills because the last thing they want, of course, is to be associated with an abuser. There's a lot of peril for folks in the public eye, and they really have a lot of potential to be harmed.
Absolutely. So much potential risk, so many potential civil lawsuits. We're always cautioning discretion and slowing down and not overreacting, but it's even more important if you are somebody in the public eye, or if you're an athlete, or if you're a celebrity of any kind, because the consequences can be huge, and breakups are hard. They're
hard. Obviously, emotions are high. They're dramatic, even in a best case scenario, right? But for folks whose name the reporters are dying to hear about, we tell them, if your ex or soon to be ex is physically coming at you, you extricate yourself from that situation, right?
As quickly as possible.
As quickly as possible.
One way out.
Swallow your pride and go for the front or back door.
Right. And people worry about what will it look like if I leave my kids. You need to get yourself out of there. So that's the most important thing.
Absolutely, because your poor kids, if daddy or mommy gets arrested, that's much worse than most of the alternatives.
Absolutely. Let's talk about prenuptial agreements. How do prenups for athletes differ, and what advice do you give to your clients about prenups?
Always a good thing. Anybody with any level of income, athletes or not, who asks me, is a prenup a good idea? I always say, definitely yes. If you can navigate that in the context of your emerging relationship, right? It's not always an easy thing.
No.
Right? If they come and they ask, we say definitely yes.
Okay. So how do you help people navigate that discussion?
Well, one thing I'll say, Billy, is too often I am shocked that they're coming to me in the midst of a family law case. They don't have a prenup. I'm just shocked that I would say most of the athletes I've worked with, they don't have a prenup. So it's too late. In Colorado, we do have postnuptial agreements. You can put into effect an agreement once you're married, but it's often too late. If they're already fighting, that's not workable. If they do come to me in advance, It's a challenging thing because they're usually coming because they're on the verge of a big payday.
Oh,
Right? They're about to move from college into the pros. They're about to maybe step up to the next big contract. Is the other spouse willing to consider it? Maybe, but probably not.
right. It seems like an opportunity for agents to have prenups that the agents put in front of the athlete and in front of the person in the relationship. And it seems like that could be a real opportunity for them to provide a service and just be like, guys, this is the deal.
You know, you would think they do it though. I know some of these agents, and they tell me, "Look, Rich, I tried. I went to the wedding. I showed it to him for the 100th time, and he went off with his buddies, and it just didn't happen."
Got it. I understand. I mean, most people don't get prenups. We know they're a great idea. They're not, anti-romantic. They don't make you more likely to get divorced or break up. You are entering into some sort of an arrangement for what will happen regardless. It's either, are you making your own rules or are you taking the state's rules? But
Amen.
we're preaching to the choir, right?
Right. If only our clients always listen to us, right?
So let's
But
talk about...
it's humanity. Things are messy, and now we're human beings. And
You're right.
far be it for me to judge. I get it. People are in love, and they do what they think is right at the time.
Yeah, and it's so taboo. It's just culturally, it's still taboo. Maybe at some point for some generation, it won't be. But today, here's where we are.
Yeah, good point.
So child custody is also complicated with athletes because they don't have normal schedules. So how
Right.
do you address that?
That's a great question. I wish I had a great answer for it. They don't have normal schedules. They're often moving around a lot, especially the major sports franchise players. They go from state to state or even in other countries. So they'll often have residences in more than one state. So we're dealing with parenting time issues in both states. We're dealing with a whole extra set of costs for airfare back and forth. And, for younger kids and folks that have the financial wherewithal, it's not just the kids that fly. It's often the kids, the nanny or nannies. It's often the other parent that goes with them, sometimes other relatives. And you have these complicated arrangements unless, and I had one athlete who always arranged for private travel. When that's feasible, it's easier for sure.
Sure, more flexibility.
A lot more flexibility.
So the thing that is so different is it's not unusual to have long distance plans. It's not unusual to know that somebody might move, but it's the fact that it happens with such frequency. And how do you avoid having to go through a big modification and relitigate the case every time something changes? How do you plan for that?
Really tough, Billy, because you can have, let's say a player is based in Denver, but he's traveling to states all in the West region. You can deal with that, and the logistics aren't terrible. But let's say that player with, say, the Colorado Avalanche gets traded to the Toronto Maple Leafs for our friends in Canada. All of a sudden, all those arrangements, the regional stuff completely changes. They're on a different time zone. And the ex typically is not the one who's moving. Just the athlete is being based and then coming back and forth. It becomes pretty complicated and really difficult to plan for.
Do you enter into collaborative agreements or arbitration style agreements?
Yeah, we do. We have mandatory arbitration of agreements. That process, as you know, is always somewhat collaborative. If you're going to mediation, then arbitration. I haven't done a full-blown collaborative divorce with an athlete. I'd like to. I think it makes a lot of sense in these cases.
I'm very interested in the idea of building in an agreement for a collaborative divorce, either into a prenup or into an athlete or some high profile settlement to keep people out of litigating if possible. So I don't know if it's going to work, but that's my idea.
I love that idea. If you figured it out, tell me. I'd love to know, because those things are always tested at the time. And
Right.
I hear from judges, look, unless everybody agrees today, I don't care what they agreed to 5 years ago. Somebody wants their day in court, they're going to get a day in court.
Oh, so they wouldn't enforce it.
I'm not sure if they would or wouldn't. It's an interesting question.
Hey there, co-parents. It's Billie Tarascio with Modern Law, and let me tell you about our Family Wizard, our preferred co-parenting app. It's a game changer. I use it myself. With features like documented calls, secured messaging, shared calendars, and more, our Family Wizard makes co-parenting smoother than ever. Trust me, I've seen the difference that it can make. Join the over 1 million parents and family law professionals who trust our Family Wizard to make co-parenting easier. Ready to take some stress out of co-parenting? Head to ourfamilywizard.com/modern law. You talked a little bit about child support. So we have the Steve Nash case in Arizona. It is the case on mandatory upward deviations. How does child support work for people with very, very high incomes?
Great question. So I followed that Steve Nash case. Boy, that was a doozy.
It was.
That poor guy, what he went through, what his ex must have gone through, I can't even imagine, right? So Colorado is different. Our body of case law is different. We do not have mandatory deviation or mandatory extrapolation, which is what I think the Nash case stands for. Correct me if I'm wrong. Where if it's above the guideline. Upward deviation. So I think something like that would be helpful in Colorado, but we do not have that. What we have is, okay, once you're above the income limit of the guidelines, which is $30,000 per month for an individual earner. So that ends up at $360K per year. A lot of money for most people, but for an athlete, they're always way above that, right? Mm-hmm. So the guidelines no longer apply. Mm-hmm. The judges say you can't automatically extrapolate to a specific number. Mm-hmm. You must look at the reasonable needs of the kids, their expenses, and what the expectation was during the relationship. And then you end up with just a potential big mess if you can't settle that out of court, because what is reasonable in the eyes of one parent is not in the eyes of another, especially in the midst of a fight.
Absolutely. That is the same for Arizona. There are conditions under which you have to deviate upwards, but there is no calculator of how much that needs to be. And
Okay.
Based on what was, from the Nash case, what was their life like, and how do they continue to have that life, those children, when they are now in a divorced household. Now, that's great when you have a married couple that live together that has a spending history. But of course, when you don't, then you're dealing with imaginations.
It is. It's a good way to put it. It is imagination. You have expectations that were set with an intact family that's no longer intact. Mm-hmm. Now you have double the household expenses with mom and dad living apart. And then you have differences in what happens with the athlete's career. I mean, as I recall, Steve went from being a player to a coach to, I don't think he's in the league anymore. Mm-hmm. And all that stuff had to be, I assume, modified each time.
Right. And that's my next section to talk to you about. My next section is post-career planning. How do you plan in these initial documents for things like injuries, early retirement, major changes?
Yeah, it's a great question. There's no easy solution, Billy. It depends on, what the specific facts are. And this is where a good lawyer really has an understanding of the athlete's sport, his or her position within that sport, the contract situation, the salary cap issues with whatever franchise we're talking about. So you can divide property at the time of a divorce, but anything involving maintenance or child support or future earnings, that's all going to be speculative, highly speculative. And what I can say is we just have to be very, very careful not to overcommit a client financially.
Absolutely. Those non-modifiable spousal maintenance awards are in Arizona. If you enter into an award that is non-modifiable, it's non-modifiable. No matter what. You could enter into a non-modifiable award to pay X for the rest of your life and suffer a paraplegic accident and be unable and only get disability income. And there is no way for the court to relieve you of that obligation.
Absolutely. Here too. And so I look at, if it's one of those situations where the client really wants closure and finality, what's their ability to find liquid assets? Gosh forbid something happens, to just pay it off and just be done with it. Because you're right, that could be a really bad situation.
Divorce, family law cases, it always takes a hit on your ability to concentrate and your performance. That is especially important to athletes or really any high performers. How do you address that?
Great question. You know, it's everything from the mechanics of when you're going to schedule a hearing date or a mediation or a deposition. I sometimes hear from my clients, look, not during, training season, not during potential playoffs. If it's an NFL player, we're working visitation. You didn't ask this specifically, but visitation around Sunday games and now Monday games. But the whole mental focus thing is something that I got to say, as a sports geek, I'm really fascinated by how somebody could be in the zone and be so focused, not only physically, but really mentally on performing at a high level. And this stuff, it really gets in the way. The strife in family law courts, I can't tell you how many times I've gotten a call on my cell phone from an athlete at midnight on a Friday night who says, Rich, you just got to end this. Make it go away. I can't handle this anymore. Tell her I'll pay her whatever she wants. And that athlete is really earnest about, look, whatever I'm going to pay in the short term, just get it done so that I can focus on my performance on the field or the court or the ice.
Do you include in your temporary agreements no contact provisions?
You mean between the parents? Mm-hmm. I haven't, but what I have done is we've tried to put parameters around the communications. We've said you have to use a certain parenting app, or you can only text between certain hours of the day, days of the week. They often don't follow that. No contact stuff is hard, much as some of the clients would prefer that. I also hear from my athlete clients that he's blocking me or she's blocking me. I need to FaceTime with the kids. So that can cut both ways.
Yeah, especially if you need, depending on the ages of your children, if you can contact them directly, awesome. If you can't, it can be really tough. But the things that go on between a couple when they're going through the process can be pretty brutal in terms of the psychological impact. So I can certainly understand why your clients would be calling you and saying, just do whatever you need to do to end this.
Value of closure, not litigating. Forget all the money they're spending on the lawyers, the other professionals. They're most concerned with that really good question you asked about focusing on their performance as an athlete. They just don't want the distraction.
Without revealing any confidential information, would you share a particularly challenging case and how you navigated it?
Sure. A number of years ago, I think it's probably 10-ish years ago, I was representing an athlete who was a father. He was a baseball player. And he and his soon-to-be ex at the time were just at war. These people hated each other with a passion of just extra, extra hate. I'm sure you've seen it, right? Litigated for a year and a half. Went to court a bunch of times. They spent a fortune fighting over everything. Day to the final hearing comes. They're finally going to get closure. I show up to the courthouse super early, like I always do. And my client, let's call him Jose, he's not there. So I start calling and texting him. Then I start calling and texting his agent. Then I start calling and texting his mom, literally, because she was involved. Nobody knew where Jose was. Judge calls the case. Turns out the wife isn't there either. We lawyers are kind of sitting there with our hands in the air, trying to apologize to the judge. We're ready to go. All our witnesses are there, except our most important witnesses, husband and wife, mom and dad. We didn't find them until later that afternoon. I got a call from my guy from a hotel room somewhere saying, Rich, call it all off. Me and Maria, we worked it all out, and we're just gonna move on and live happily ever after. And the best part about it is, as far as I know, they did.
Wow.
I think they stayed together somehow.
Wow. That's a great story.
Yeah, thank you. Yeah.
And
I was happy for him.
Yeah, I mean, reconciliation is awesome. I'm assuming you were not able to convince him to get a post up at that point in time.
Nope. He did. Much as I got along with this guy, we were really close for a year and a half. I mean, texting all the time. He did not want to hear from me at all once he and Maria reconciled. That was the end of it.
That's
and
great.
I only heard from him occasionally, either from the agent, or I followed his stuff in the news. But he ended up having 2 or 3 more years in the league and a pretty good career, and he made good money. I hope he lived happily ever after.
That's awesome. That's a great story. I like that story.
Happy story.
Yes. Have you observed any trends or changes in the way that professional athletes are approaching marriage and divorce? Is social media having any influence on or the evolving nature of sports contracts?
Yes, to all the above.
Okay.
Let me hit on social media. Boy, what a different world it is, and you obviously see it too with our regular clients. I don't know what a regular client is. That's a poor phrase, but for clients that aren't in the public eye, we're telling them, look, be careful what you do or say on social media. If you can, maybe lose it for 6 months while we're working together. Make sure you're careful about what you post, right? With athletes, it's almost not an option to not post because it's part of their brand. And they often have multiple outlets. They often have third parties who are running their social media exposure. And there's often significant income streams from all these things. So we can't tell them don't post. And the reality is, what most of us like to see on social media is the most prurient, the most salacious stuff. And it's really hard for them to avoid getting into. They're posting about their trips and the cars they bought, and going to the parties with actors and other A-listers, and it's part of their brand. It's part of their deal. And boy, that stuff ends up being evidence for the other side in a way that we would not prefer. So that's a challenge.
Yeah,
for sure.
Absolutely. I didn't think about that, but they're probably making quite a bit of money from the views that their social media platforms are generating.
They are. And even their spouses and exes can have their own publicity and income streams just from being with whoever it is. And we see that. We see people whose job is just posting and being, it's called an influencer, which is a term my teenagers taught me. Mm-hmm. But apparently it's part of the real world now. People who are out there just with online presences.
So how do those confidentiality agreements that you talked about impact your ability to show up on social?
Yeah, it's really hard. We tell them to be careful what you say, be careful who's in the images. And it's not uncommon for us to be contacting the other side and saying, look, you better take this down or else, because they're always approaching that fine line.
Right. And if you've got other people running that account,
Yeah.
it may make sense for that person to run those posts by your lawyer.
I wish they would. I wish they would. But those people are paid by the eyeballs they're attracting, and
Sure.
they don't want to typically.
Right. So we've got some conflicting interests here for sure.
For sure.
All right. What advice would you give to athletes before considering marriage?
Athletes considering marriage for sure should think about a prenup. Even if they don't think about a prenup or think it's a bad idea, think about it again and talk to others. The NFL in particular does a good job with educating athletes coming out of college. They have this whole financial university process where older players or veteran players are counseling them. The NFL gives its players a lot of support. And for an NFL athlete, I'd recommend that those players take advantage of that for sure. They should be consulting with others they trust and respect, not just all the folks that are out to make money off of them. They should be careful about media folks and others that are just in it for the money. Talk to people they trust. So get 3 or 4 opinions from lawyers for sure. Get recommendations from other players who have had good experiences with lawyers. Not every family law attorney can handle an athlete case well. You want somebody who knows what they're doing, not just technically, but in terms of the nuances of these cases, keeping them out of the public eye, for example. These things are really, really important for folks.
And then what about those cases where you're just dealing with paternity? So a client comes to you and they just found out their girlfriend's pregnant.
When we hear that, like a lot of these guys or gals, it's almost always the guys, we tell them, let's get a test. It's not always the case, and sometimes they don't want to hear that, but we always need to get a test to make sure. Then if they're definitely the father, and they want to be involved. And I've been fortunate. Most of my fathers in these cases have really wanted relationships with their children, which is really a great, it's fun as a lawyer to represent somebody who really cares about their kids. If we can get ahead of the paternity thing, we've had cases where we have affirmatively filed the paternity case to get their father's legal rights established right out of the gate. Don't wait to be sued. In other words, you sue the other parent to establish your rights and to let everybody know you're showing up as a dad financially and in every other way.
Absolutely. So that's going to make a big difference with their image, but also could head off litigation. Most of the time, I mean, if it's your girlfriend, hopefully you guys are on the same page, and better to get an agreement when everybody's on the same page.
For sure. Agreements are always best in our world, as you know.
They are. I mean, when everybody's getting along is the best time to write things down.
For sure.
Have you heard of athletes buying annuities to pay for things like child support? Yes,
great question. Especially during their high earning years, I have seen the financial handlers around these folks push them because they have a lot of cash typically. There are tax advantages for some of these plans, and you make a big investment, you put it away for the benefit of the kids. It's peace of mind financially to the athlete, and boy, does it ever look good for the judge that when I can stand up in front of a judge and say, look, Your Honor, not only is he paying X thousands of dollars per month right now, but he set aside this annuity to make sure that little Johnny is going to have a college education and his first home and his first car all in the bank for him. And judges love that. It shows that they're being responsible.
Okay, so let's talk about how that works. So to get an annuity, you pay a certain amount of money now for the promise of an income stream forever, right?
Right.
Well, could that be child support?
It could. We've had the best success when everybody agrees it's child support. Now, hopefully everybody's above board and it's a legitimate investment and there's a real income stream from a reputable company down the road. The judges are really leery if somebody's trying to get away with it by something more sketchy. But it can be considered child support if the annuity is paying out. It's typically not, in my experience, deemed child support the year you make the investment and establish the corpus of money. That's just putting money away. That's savings.
Okay.
But when it's in payout, it can be considered child support, yes.
Okay, awesome. So last question. You have been wonderful. I have really enjoyed this podcast and getting to learn more about this topic. Certainly interesting. How has representing professional athletes impacted your career, your view on marriage, privacy, and wealth?
Oh, wow. What a great question. Thank you. First of all, thank you, Billie. This has been fun for me too. And you asked some really great questions. I think that I'm a lot more sensitive to privacy issues than I used to be, not only for high earners, but for everybody. I've always been the kind of lawyer that likes to settle things out of court and get agreements where possible. If we need to litigate, we litigate and do that. But to have the privacy and the confidentiality that folks in the public eye demand, to give those same protections where possible to everyday, if you will, divorce cases, it's a great thing. While we have, by and large, really good judges in our state, our court system is crowded, it's public, it's clumsy, it's delay prone, it's all those things that you know. We look at private arbitration much more often. We look at even settlement conferences as often as we can between just us lawyers, even without mediators where we can. The more privacy, the more discretion, the less people are out there. I think it helps people heal. For folks that are going through what is often the worst trauma in their life, barring maybe one or two other things, the healing part of what we do, I'm sure you do too. We think about that.
Absolutely. I absolutely do, especially as somebody who's gone through it. Like, it's so invasive. It's incredibly invasive. I didn't even think about how invasive it was until I'm like, I have to show my credit cards to somebody else. It's very, and of course, right? Of course you do. But that's very invasive. And so if you can come up with a way to, if you can come up with a way to make a deal, you're setting yourself and the other parent up for future success in co-parenting, which is a big deal, cannot be overstated. But I agree with you. I think it does help with the healing process.
It really does. It really does. And, at the end of the day, hopefully as professionals, we're not only protecting people's legal rights, but we're protecting their dignity. We're protecting their ability to move on as healthy parents and hopefully wage earners and move on from a trauma.
Rich, thank you so much for coming on the show. I have really enjoyed it. And if you all have enjoyed this episode, make sure to like it, download it, leave a review, and let us know if there's any other topics you'd like us to cover here at the Modern Divorce Podcast. Thank you.
Appreciate it, Billie.
Thanks so much for listening to the Modern Divorce Podcast. Remember, anything you've heard today or anything you read online is not the replacement for actual consultation with an attorney and does not create an attorney-client relationship. Even if you called in and we spoke to you, you were anonymous and we don't have your details and you have not become a client of Modern Law. However, we would love to speak with you, or you should seek out the advice of legal counsel or counseling or any other expert near you. And if you have an idea for a show topic or you need to speak with an attorney in Arizona, you can reach me at info@mymodernlaw.com.